Okay, abusuaba makwa abashonko so edeba POG Media so. Abusuya yembonra yensemu breaking news bi aba eno ene ya project ede ato ye screen no enchen ede amamono. Former Chief Justice Torkornoo urges ECOWAS court to deliver judgments in her favor, insisting the Attorney General has failed to file a response to the case within the required time. Abusuya suspended and as a former Chief Justice Torkornoo, Abusuya maame no upon the akoso bia no onte ne ho ase say sa 5-member committee no omo finalizing the process no e dey akoma President Mahama so ayeden ejina constitution ne so e dey apam no na ene wasan so akọ ECOWAS for no ho bill se onte neoma bia ase wo ho abusuan we ni breaking news a e wo ho a yen so ye de bremo mom yen ko na yen konkotie ensem bi nso a empanfo bi ere tudwa unsubscribe ya subscribe like na share ma for so ensa entumi enkabia ha POG Media so madam ase.
The point, I have never considered the point. The point is that even within the established judicial system, when you disagree with the court, you don't go publicly to litigate your matter.
But what do?
You escalate the matter.
But in this matter, there's no other
avenue. That is why it's bad.
It's finished.
It's finished.
Yeah, so...
Too bad for him.
So
when you are litigating the matter, to what end? To what end? So, Mr. Ayuko is really litigating the matter on Joy FM to what end?
Yeah, but okay, so there's a public interest question.
What public interest?
I mean, for all of us, this matter is the biggest.
That is why
matter as far as our democracy is concerned, in the Fourth Republic at least, right? The implications are there. If we now thankfully now know the reasons, we shouldn't talk about it, at least for posterity, for public education.
So when you are talking about it, you invite the committee members to come here.
Oh, of course.
Because he addressed them, they listened to him, and the other party, because they had 4 lawyers representing the Chief Justice and 4 lawyers representing Addo. Yeah. So you will invite the other party to come and respond, rebut to what he's saying.
On a substantive matter, though, having seen the reasons, you still believe that the Chief Justice didn't have a case. They talk about, for example, the unlawful expenditure of public funds. Mr. Sanra, I need to bring you in on this. First of all, I know you had a comment on this first disagreement.
Yes, I think both my good friend Nusa and Ayuko too, have gotten it wrong. You see, Ayuko too has been invited by Media General.
Johnny's.
Yes. So, there's nothing wrong, but, he has a point in the sense that since Ayuko too has been invited, then Joy might as well have invited the others, so because
as the committee members.
Yes, to come in. So if you give a platform to one side, the other side, so it's a breach of natural justice. But more importantly, the point he has made that it is sort of giving Ayuko to a platform to re-litigate what he has litigated already. And as a former Minister of Justice and Attorney General, he knows, or he ought to know, that there's a huge merit in the point that Nusa made. But if there is any blame at all, it should be laid at the doorstep of the entity that invited Ayuko to respond. This is, as you said, this is a matter of public interest. But I would have thought that in inviting Ayuko to come, Joy, could also have invited the other side.
It's
for a balance.
The committee members.
Exactly.
There's no way the committee members. It will be actually on the
and Ayuko would be right in saying that in that case he would not. I thought he was going to say that if it is a panel discussion, then he will not participate. When he started, I thought that was what he was arriving at. However, this whole issue of spending whatnot, must be put in the context of the terms and conditions of, Torkornoo's appointment. It's a contract. Mm-hmm. The issue is whether or not the expenditure incurred based on terms and conditions of the letter of appointment, availed that opportunity. Did her letter of appointment contain, what she did? If yes, I don't see any infraction. If no, then, it may be a contravention of the rules. So it's all a matter of contract.
Yeah, but there's
contained in terms of appointment or not.
There is a travel policy. And I want to read the relevant portion, which really should answer the question. And this is a B2 under the judiciary travel policy. It says, where the Chief Justice, yes, is entitled to travel. However, it says, B2 says, where the Chief Justice embarks on a personal or private foreign travel, he or she shall be accompanied by the security alone. This is a quote. But in this case, and she doesn't deny, she traveled with the spouse, who obviously is on the security. And the spouse also got onto the per diem provided by the state, which is the conclusion that that was an unlawful expenditure of public funds.
Meaning that, they were not contained in a contract of appointment.
That she can travel, but if you're going with your spouse,
yes. So that's a violation. Yeah. So for me, if it is, a contractual issue and she sidestepped, the terms and conditions, of a contract, I mean, she's been in infraction of the law.
But don't you surcharge and sort of remove her? That's a point that he's making, that there's a former Auditor General there on the committee who should have known that.
It is not, for the former Chief Justice to decide, whether the Auditor General, should have surcharged. I mean, that is neither here nor there. A more fundamental point, which I find a bit erroneous in the submission of, my classmate Aiko to, is that she was not the spending officer. As head of the judiciary, she was the spending officer. And if you are traveling and the finance, unit brings you something that you are not entitled to, you cannot say, that the spending, the finance, office should have known the buck stops on the desk of the CJ. So if there have been any, financial misfeasance, she must accept the blame.
There's something very interesting here. When you read the travel policy, the custodian of the policy is the judicial secretary. Remember, the judicial secretary resigned when the matters became public. She resigned. So why do you blame the Chief Justice? The judicial secretary should have known.
The judicial, you see, the judiciary is separate and distinct from the judicial service.
Okay.
The judicial secretary is the administrative and technical head of the judicial service, which is the personnel and administrative wing of the judiciary. They provide technical support and administrative support. But the head, the judicial service, is part and parcel of the judiciary. Yeah. So the head of the judiciary is the Chief Justice, not the judicial secretary.
Okay.
Therefore, if the judicial secretary does something, that to all intents and purposes the Chief Justice realizes is a wrongdoing, she cannot, as it were, hide behind officialdom and say that this is coming from the judicial secretary and therefore, see no evil, hear no evil, feel no evil. That kind of, attitude will be a wrongful thing.
So you agree with the committee when it says this is unlawful expenditure of public funds?
I mean, if it was extraneous, outside a constitutional,
But when if it's unlawful, what law? What law does it breach? That is the key question. Because they say here, quote, unlawful expenditure. It must have breached a particular law.
the law on spending, if you are a head of department, you have been given either some funds, and it is not the Chief Justice to administer the funds. It is for the finance officers there or the Judicial Secretary. This whole thing, it is a disease. It's a national disease. It is not only the Chief Justice. The fact that some of these things have not been unraveled in the past doesn't mean they are right. Our administrative officers have over the years treated public funds as though they are personal funds, and this is the first time that I believe we have had a committee that has been brutally frank that this is wrongdoing. The error here is that Article 295 of the Constitution does not define stated misbehavior. That is the problem. You see, and
the point. There's no definition.
No, and I think that the Constitution, the Committee of Experts did not anticipate that something like this will happen, and therefore did not advert their mind. If they had contemplated this arising, they would have provided for it. But the Committee of Experts did their best. It's up to the operators to decide.
Let's ask one more question on this, and then we'll deal with the procedural and big governance and democratic questions that come up. Ms. Aikotu, how do you respond to that clause in the policy? Because you cite that, which says that where the Chief Justice embarks on the personal or private foreign travel, he or she shall be accompanied by the security alone, which we know didn't happen in this case.
You see, I told you that I was not prepared for a panel discussion because those that you bring on board were not in a room with us. And therefore, there are things that they will be saying due to conjecture or things that have, been leaked into the public sphere. I don't think they are aware that these policies were amended. I made a point to you that there was a point when we had a head of the judiciary, a Chief Justice, who had no spouse. So some of these things were amended to say that he could travel with anybody of her own choice. And according to the travel policy, when whatever he gets, the other person will get half. That is a travel policy. They work. I don't know whether my friend doesn't know who a spending officer is. And he's making this kind of presentations here. The spending officer is held responsible. When the auditors come, they tell her, look, if you don't get this money refunded, we are going to hold you responsible for it. She is responsible. The Chief Justice is not. I traveled as minister, as High Commissioner. It is the spending officers. They work on these things and bring it to us. We don't get involved. If it is accountable interest, when you come back, you will make your account by retiring whatever was given to you. In this matter, she retired 2 days after she returned to this country, and yet it was all over the place that she has not retired the impress. And I'm saying again that it is a travel policy which said that whatever is given to her, whoever she's traveling with will get half that amount. And the policy they said does not cover public officers was explained that in view of the peculiar situation of the judiciary, everything financial has got nothing to do with what they do in the public service, but what the judicial service does as an independent autonomous body. And that once they have approved that this is the way it should be done, that ends the matter. You can't import things from the public service into the judiciary. It is not everything that you can bring there.
But on the subject of the process, though, you can see that this was one that was fairly within the remit of the Constitution, and the process was followed to the letter.
What I'm saying to you is that because the Constitution makes the judiciary financially autonomous, what they do there is their business. So what we have to do or look at is the policy of the Judicial Council. What is their policy? What did they say should be done?
But beyond that,
what was the position as at the time that she took that travel?
Beyond,
and when the standing officer ensured that she was paid all those things.
Beyond the specifics of the travel policy and what she spent or what didn't spend, a recommendation has been made today. Did you get an opportunity? I think I heard you say today that your written submissions, you sent them only today on the Daniel 41.
You see why I said I would have loved one-on-one? Look, we were asked to file our written addresses by last week, Monday, or was it? Yes, and we said we needed 1 week because look, we are talking about 10,000 pages of exhibits.
Only on the Daniel 40 petition.
Only on the Daniel 40, the only one. So we asked for 1 week. That week will end today. Is it today, Monday? So this is the day that we were going to file our written submissions before the close of the day. And before we could say, Jack, this report had already been issued. They did not take any submissions into consideration. And you are saying we should not talk about it? They did not listen to us. These 10,000 pages that they are referring to, and how we saw them, these issues that we are raising, the exhibits that we wanted to make use of, which we have made use of, were never allowed to be filed because they just didn't want to know anything. They have just finished and presented their report. This enlargement of the Supreme Court, which they are using today against her, was it not the same reason they used to say that she had already asked for expansion of the judiciary? So Mahama has also decided that he will elevate 7 people to the Supreme Court. Haven't they done that? Where is the justice and fairness in what we are doing?
But please stay with me on that point. Justice and fairness, Yusuf Hussaini. How do you respond to that? This is going.
First of all, yes, I agree that probably it was a lacuna by and that trace goes back to 1969. The Article 146 has antecedents in the 1969 Constitution. That was the time that the country decided that they must remedy what Nkrumah did in the First Republic and provided for a procedure for removing a Chief Justice. And since 1969 to date, they have never made an attempt to define what state misbehavior is. Probably they thought that was understandable. Okay, doing something which clearly is not within your mandate. Doing something that smacks of impunity, judicial impunity, which lacks accountability and so
use of office.
Use of office. Probably that's. But I think that I should think that the Constitutional Review Committee is watching this program, and so maybe they will take steps to define. So I agree. But Mr. Ayuko to say is the abuse, even if it was an abuse, ought to have been within the realm of a surcharge. Surcharge is an unlawful expenditure. You surcharge somebody for unlawful expenditure. Expenditure that is not grounded, founded in law. That is not permissible.
So you're saying that in itself is an admission that there's been misconduct?
That itself is an admission that conduct is wrong. And that's why that person has been surcharged. Okay? Now, so all that we are trying to do here is how do we deal with judicial impunity? How do we ensure? And I hear arguments by Mr. Ayuko Utu, which is frightening. For instance, it says that the judicial service should conduct their financial affairs with a regard to what happens anywhere. And that so there should be a law unto themselves. That again founds what we call judicial impunity. And that can lead to an abuse of the process. That that is definitely inconsistent with good governance within any institution. Definitely. That you become a law unto yourself? No. Because basically, public resources are resources for the public. And no one has the right to spend public resources without recourse to the law. No one. Now, what has happened, like I said, derives from the 1969 Constitution. It was then that the people, the constitutional experts, thought that we should insulate the process of the removal of justices of the Superior Court of Judicature from partisan political consideration and ensure that a body like a Council of State is established, which, if you read the 1969 Constitution, will tell you what was intended for the Council of State. And as the name suggests, should be a Council of State. It should be state matters that will agitate the mind of the people. So that's why a petition received by the president is not forwarded to Parliament. In the United States, a petition received for the removal of a justice of the Superior Court of Judicature is sent to Congress. In Britain, it's sent to Parliament. But in Ghana, we said insulate it because the arena of politics is in Parliament. That is why, to safeguard the integrity of the whole judicial service, you find a lot of checks and balances in Article 146 and its antecedent provisions.
So you're saying that is why when the prima facie is made by the council,
yes,
the president must suspend.
Yes.
The first real action only happens when the People's Council, as in the Council of State,
yes,
makes the prima facie.
Yes. And that is why the president has no jurisdiction, even though he's a Ghanaian, to send a petition to the Council of State for the removal. He says a citizen of Ghana. And, well, one might say that he has not exercised it because he's a citizen of Ghana. But the president's jurisdiction to act on a removal process is triggered by a petition. So he cannot, on his own, just say, well, Council of State determine whether the Chief Justice should be removed.
But
it's a check.
But I know, but that process can be engineered politically.
Well, you are saying that. That's why the process itself reposes a lot of trust in the committee. That's why the process is not designed to be, if you want, litigious. That's why they say lawyers should not be part of the committee. That's why they want the process to be understood by us. That's why they say members of the Supreme Court who sits together with the Chief Justice must be on it. So that they will understand exactly the points that are being made by ECOWAS. Is that the procedure because they are part of it? So when you look at the architecture of Article 146, its design, its conception, design, and implementation was intended to protect justices of the Superior Court and chairman of regional tribunal and insulate them against political manipulation. Look, why do we say, why is there an Article 1466? Because the head note of the provision 146 says removal of justices of the Superior Court of Judicature. Where the application affects a justice of the Superior Court of Judicature, you send the application, the petition, to the Chief Justice. The Chief Justice for the establishment of a prima facie. But the Chief Justice, you know, Mr. Atasare has just told you about rules of natural justice. The Chief Justice cannot be a judge in her own cause, even though she's a justice of the Superior Court of Judicature. So if a petition is for her removal, you can't send the petition to her, can you? She'll be a judge in her own cause. So the drafters of the Constitution, in trying to deal with that problem, came with an institution called the Council of State. So you see, the checks and balances, clearly, I'm not saying that it's perfect, because even now we've just seen clearly that the misdemeanor has to be, misconduct has to be defined. Yeah. We just seen clearly. And if you look at the report on the constitutional experts, they say that detailed rules of practice and procedure for the removal of Chief Justice must be brought into being by the committee, court committee, so that will bring about more fairness in the way a Chief Justice is removed. So I'm not saying the process is perfect, but when you read carefully from Article 1461 to the last provision of Article 146, you will be left in no doubt.
So your verdict is that this process has been terminated now, but if you look at it, it comply with the constitutional dictates.
No, look, the Bar Council of Britain and of England and Wales said the president must restore the Chief Justice. The Commonwealth lawyers, even our Ghana Bar Association, have said they have problems with that. But no one has said, no one, and Mr. Asari just said this evening, no one has said that there has been a flagrant violation of the provision.
What about the rule of natural justice? He just makes the point that even their submissions were only taken today and the decision already been taken.
That's the procedure within the committee. We're talking about Article 146.
Yeah, but of course,
So,
I'm not talking about the constitution now. You're talking about the rule.
We don't know. That is why you ought to have invited the other party. We don't know whether they were given an opportunity to file and they failed, refused, or
on the face of what he has said. Though.
No, I can't understand. I can't comment on it on the face because there are many things that would have happened. As a practicing lawyer, judges give judgments without taking the submissions of lawyers.
But on this matter,
but they only do that if the lawyers fail, refuse, or neglect to comply with directives given in court for the filing of the submission of no case. For the filing of their the written submissions. And so clearly, I don't know. I was not part. I didn't invest in the process of what was happening. I invested in the constitutional provisions, whether or not the fidelity of the provisions of the Constitution was being complied with.
Yeah, I mean, I'm so sorry. There's another key point here. There were 3 petitions. Only one was the basis for this recommendation to remove. And we are told that the 2 will be heard later. Why? Is this legally sound?
They agreed from what we are learning now. They agreed, that the second and third petitions, could abide the outcome of the first petition. And
Nobody
that's the law.
said that.
The law is the law.
Nobody said that.
So if
Nobody said that.
So if but that is the screaming headline, that appeared today.
Which is what?
That
I'm saying nobody said that.
The petition.
Nobody said that.
No, but yes,
Okay, abusua we ne ensema ekoso ewo political highway so a year suspended and as a former Chief Justice Torkornoo Torkornoo and I see our son so akwa pimo ewo ECOWAS enye asam keto akra beda mase se mo je pene kokoti ensema ekoso aha POG Media so beda mase.